The fourth capsule, I will discuss two legislations, very recent, in the 1990s and in 2000s. One is the Protection of Women from Domestic Violence Act, 2005, and the other is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013. The reason why I take these two legislations for discussion is for the following reasons. Number one, these two legislations covers two sites. One is the domestic space, the other is the workplace. In the first, that is the Protection of Women from Domestic Violence Act, we get an idea as to what is a shared household. And in the Sexual Harassment Act, we get an idea as to what is a workplace. So both inside the home and at the workplace, how is it that we have laws which protect and secure women's equality and dignity is something that we will see through these two legislations. A second thing that we need to remember with respect to these two legislations, and the reason why I'm bringing these together, is both of these legislations have a huge history in the Indian women's movement. The Protection of Women from Domestic Violence Act, which eventually came into existence in 2005, its discussions began from 1995. It is a separate legislation for domestic violence. It is a civil legislation for domestic violence as opposed to a criminal law provision that exists in the Indian Penal Code. And from 1995 to 2005, there have been nationwide discussions with different women's organizations about what should come into the Protection of Women from Domestic Violence Act. So in some senses, this is a legislation which is scripted by different women's organizations in India, of course, approved and debated in the parliament eventually. The Sexual Harassment for Women's Act, which comes in 2013, has a similar kind of a history. Its history goes back to a 1997 Supreme Court judgment, which is famously known as the Vishaka judgment, which for the first time gave us the definition of sexual harassment, told us what is a hostile work environment, and also ensured that employers should prevent the creation of a hostile work environment for women employees. After 1997 Vishaka judgment, the process of having a legislation on sexual harassment began from the 2000s, because a judgment is not mandatory to be followed. So we needed a law. So this legal process also had deliberations and discussions with different women's organizations. And we eventually had the legislation in 2013, an important moment in the history of lawmaking in connection to, specifically in connection to women's law reform, because it comes after the 2012 Delhi gang rape. As I was mentioning in the last module, that there have been rape law reforms that has happened after the Delhi gang rape. The Sexual Harassment Act also comes into being in 2013 after the Delhi gang rape. And you also had the Justice Verma Committee report of 2013, which emphasized on the importance of a legislation like this in India, and also the importance of enshrining that women in the workplace are there, feel secure, and work with dignity. So with these two reasons as to why I'm bringing these two legislations together, let me talk very briefly first about the Protection of Women from Domestic Violence Act. The Protection of Women from Domestic Violence Act talks about four kinds of abuses. The first is physical abuse, which would mean an act or conduct which would cause bodily pain, harm, danger to life, limb, or impair the health or development of the aggrieved person. The aggrieved person is a woman under this legislation. The second kind of abuse is sexual abuse, which would include any conduct of a sexual nature that abuses, humiliates, degrades the dignity of the woman. The third form of abuse is verbal and emotional abuse, which includes insults, ridicule, humiliation, name calling. And very specifically, it also talks about the insult or the ridicule, especially with regard to not having a child or not having a male child. And the fourth is economic abuse, which includes deprivation of all or any economic or financial resources to which the woman is entitled to, or disposal of household effects or alienation of assets, whether movable or immovable, in which the woman has an interest or is entitled to. And finally, the prohibition or restriction to continued access to resources or facilities which the woman is entitled to use or enjoy by virtue of being in a domestic relationship. So these are the four kinds of domestic violence. These are the definitions of domestic violence that we see in the legislation. How is a domestic relationship understood in this legislation? A domestic relationship means a relationship between two persons who live or have at any point of time lived together in a shared household, when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or are family members living together as a joint family. So it's important to understand that this is the first legal recognition that we get in India about what constitutes a domestic relationship, which pushes the contours of a domestic relationship beyond marriage by calling a domestic relationship a relationship which could be in the nature of marriage, but which could also be adoption. And finally, the other definition to keep in mind is what is a shared household. So given that this is talking about a domestic space and violence that happens in a domestic space, how is this shared household understood? It is a household where the person who is aggrieved, that is the woman, lives or at any stage has lived in a domestic relationship, either singly or along with the respondent, and includes such a household, whether owned or tenanted, either jointly or individually. And it could also be a joint family of which the respondent is a member. So this is how a shared household is defined and understood in the Domestic Violence Act. What is very significant with respect to the Domestic Violence Act is that the Domestic Violence Act, together with defining what domestic violence is by saying what is a domestic relationship and what is a domestic shared household, for the first time in India in 2005, all women through this legislation get the right to reside in a shared household. So something like a right to residence is what women in India get in 2005, which says that every woman in a domestic relationship shall have the right to reside in a shared household, whether or not she has any right, title, or beneficial interest in the same. The reason why this is so very important is that women in India fear reporting incidents of domestic violence in police stations. Domestic violence still remains a familial affair, and it is talked about and hushed up inside the family. The reason being that if women take this matter outside of the family into the criminal justice system, then the question might arise about what would happen if the woman is thrown out of her matrimonial home and if the woman is not taken by her natal family. So this fear of losing residence, this fear of houselessness is something which has prevented women from reporting cases of domestic violence, more importantly, from keeping and bearing, tolerating different kinds of domestic violence. So right to residence is something which the 2005 Act gives, which is a very important provision. I move to the Sexual Harassment of Women at Workplace Act of 2013. What is important to remember is that this particular legislation, which comes eventually in 2013, builds upon the constitutional provisions of Articles 14 and 15, which we've already discussed, but also Article 21, which is right to life and liberty, which is enshrined in the Constitution. Together with it, this legislation also talks about the International Convention on the elimination of all forms of discrimination against women, which India had ratified in 1993, commonly known as the CEDAW. So this legislation is based on the principles of the Constitution as well as the principles of CEDAW, which India is a signatory to. Based on this as the preamble, the way in which sexual harassment is defined in this legislation is the following. Sexual harassment includes any one or more of the following unwelcome acts or behavior, whether directly or by implication. Namely, number one, physical contact and advances. Number two, a demand or request for sexual favors. Number three, making sexually colored remarks. Number four, showing pornography. Or number five, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. While this is a definition which we see in 2013 legislation, this is the same definition that we saw in the 1997 Vishaka judgment. The other important thing that we need to remember in this legislation is the definition of workplace. And it includes department, organization, establishment, undertaking directly or indirectly by the government, by the appropriate government. Secondly, any private sector organization, undertaking, enterprise, non-governmental organization, educational organization, entertainment, industry, health services. Number three, hospitals or nursing homes. Number four, sports institutes, stadiums, sports complex, etc. Number five, any place visited by the employee arising out or during the course of employment, including transportation. And number six, a dwelling place or a house. So you can understand that with these, 6 types of explanation around what is a workplace, we traverse from government institutions to non-government institutions to educational, vocational, entertainment institutions, sports facilities and institutions, as well as a journey that you're making. So transportation for purposes of work. And finally, also the house. Why is it so? This legislation for the first time recognizes domestic workers as coming under the Sexual Harassment Act. Now, where do domestic workers work? So what is the workplace of the domestic workers? The workplace of the domestic worker is a dwelling. Is that shared household whose definition we got in the Protection of Women from Domestic Violence Act. So they are bringing domestic workers or people in the unorganized sector also under the Sexual Harassment Act, which is something which is very, very significant. But another significant thing that we get in this legislation is the importance of how do you prevent sexual harassment. Now, the reason why this is significant is that we don't get legislations which usually talk about prevention. We usually get legislations which comes into existence after there is an act of violation that has been committed. The Sexual Harassment Act talks about how do you prevent the act to be committed in the first place. And it says that no women shall be subjected to sexual harassment, and the following circumstances would amount to sexual harassment, like implied or explicit promise of preferential treatment in her employment, implied or explicit threat of detrimental treatment, implied or explicit threat about her present or future employment, interference with her work or creating an intimidating, hostile work environment, and finally, humiliating treatment likely to affect her health and safety. So the component of prevention is something that is very important. This legislation talks about the creation of internal complaints committee and the role and the importance of these internal complaints committee, lays down the procedure of an inquiry, how is it that the inquiry report has to be submitted, etc. So what we see through these two legislations is, again, two principles, two intercutting principles, I would think that this refresher course is conceptually talking about. One is recognition, the other is redistribution. So recognition of women as equal citizens to guarantee them dignity, and redistribution of resources and opportunities to keep in mind that neither families nor workplaces are gender friendly naturally. And because they are not, that is the reason why you need these laws which would try and protect, try and ensure justice for women, both inside the homes as well as in their workplaces.